Whilst I'm very reluctant to discuss the merits of the case, I will briefly say that the monies that were given to Capital Bank were given to Capital Bank, neither to Essel, neither to Fitzgerald Odonkor, neither to Nettie, neither to the lady accused person, Kwoti Papafio. The money, as the lawyers for the defense themselves said, was given to Capital Bank. Basic principle in law is that a company is a separate personality from the individuals. So if money is given to a bank, and mind you, for a specific purpose, and then individuals, be it that they have any interest in the bank, they are still separate and apart from the bank. If they use it differently in a manner which is not consistent with the purpose for which the bank advanced the money, certainly there must be a problem.
Hello, good evening and welcome to this edition of Good Evening Ghana. Thank you very much for your time. It was court day this morning at the Accra High Court where the four accused persons over the Capital Bank matter were arraigned before court. You heard the letter that Adom-Otchere speaking about the facts of the matter. Tonight we'll spend some time to look at the charges against the various individuals points in the studio to help us understand the whole gamut of operation of the Office of the Attorney General Department. There are points in the studio also for another matter. On the occasion of his 20 years at the bar, he put together a book on contemporary trends in the law of immovable property in Ghana, a very huge, large book, and we are congratulating him and celebrating him tonight for such a huge effort. That's the book in your photograph there, the contemporary trends in the law of immovable property in Ghana. And I do like the design. You know, if you look on the top of the, you look on the top over there, you see the way the old buildings used to look like. That's what you see now. And then he follows up with how the modern buildings look like. Okay, so that's the book, Contemporary Trends in the Law of Immovable Property. We'll be talking about that with our opponent. He will tell us. Okay, I'll take a short break and come back to you because I hear my sound has to be correct. We'll be right.
If I don't see this wedding with my own eyeballs, dear, it's not me.
Church rise.
I just go into the church. Okay, let me connect my earpiece.
Now you may. Renano.
Yeah. Come and see some food stuff meats by they are sharing here. False alarm. Buffet, papa.
Enjoy even more value with MTN Free After One. You only pay for the first minute of your call on MTN Free After One, and the rest is free. Plus, you enjoy free 50 megabytes worth of data to browse your favorite sites. Umpe where? Umpe deng. Dial *315# to sign up now.
We day for you everywhere you go.
The merits of the case. I will briefly say that the monies that were given to Capital Bank were given to Capital Bank, neither to Essel, neither to Fitzgerald Odonkor, neither to Nettie, neither to the lady accused person, Kwoti Papafio. The money, as the lawyers for the defense themselves said, was given to Capital Bank. Basic principle in law is that a company is a separate personality from the individuals. So if money is given to a bank, and mind you, for a specific purpose, and then individuals, be it that they have any interest in the bank, they are still separate and apart from the bank. If they use it differently in a manner which is not consistent with the purpose for which the bank advanced the money, certainly there must be a problem.
Sorry, we have to restart the program because apparently my sound was not working. Can you hear me now? All over the world, in Accra and other parts of the world, live by Facebook. Can you hear me? I'm sure you can. Thank you very much. Welcome aboard. This is Good Evening Ghana, the first edition for the weekend. Tonight, our full topic is about day one of the court. As you know, this morning, 4 persons were arraigned before an Accra High Court, Commercial Court 7, before His Lordship Justice Chebafo. They have been accused of 32 counts of criminal offences relating to the operations and the eventual closure of the Capital Bank Ghana Limited. The 4 include Mr. Adom-Otchere, who gave us a stupendous interview 2 weeks ago. Of course, the learned Attorney General called him Acel. The name actually is Essien, like the footballer Michael Essien. He is William Adom-Otchere. He's the first accused. With him also is the former managing director of the bank, the Venerable Reverend Fitzgerald Odonko of the Harvest Church, and also accused with them it's Mr. Dr. Tetenete, who is the managing director of a company called MC Management, allegedly involved with Capital Bank one way or the other. And then a lady, the AGI mogul, her name is Kate Korte Papafio, one of the photographs, one of the women that all the business people are very proud of. Kate Papafio is on your screen right now. She's with Reroy Cables. She's the proprietor, founder of Reroy Cables, and is an AGI mogul. Here is William Adom-Otchere, and of course, quite well known, and as I said, who gave us that interview the other day. This is the Right Reverend Fitzgerald Odonko of the Harvest Church. Fitzgerald has had a lot of experience in banking. He had already worked with the Echo Bank and also with the Merchant Bank in those days when Mr. Peter Iliasu was the MD. So that's Fitzgerald Odonko in your shot. He is a Reverend Minister. We don't have the photograph of Dr. Tetenete, and so he's not here yet. So today is the day one of the court, and we're going to spend some time on the matter with one of the finest lawyers in the studio. Tonight we're doing 2 things with lawyer Yao Daniel Opon, because he has celebrated, or he is celebrating 20 years of practice at the Ghana Bar Association, and in commemoration of that, lawyer Opon has put together a fantastic book. The title of the book is Contemporary Trends in the Law of Immovable Property. I bet to say that if all the lawyers will put up a book and the 20 years of their call, Ghana by now would have had a huge volume of legal information all over the libraries and all over online. This is Lawyer Opon's book, Contemporary Trends in the Law of Immovable Property, put together by Lawyer Opon. And as you can see, I like the back because he shows the travel trend of immovable property from the huts buildings up until the modern buildings. So we'll be talking to Lawyer Opon and celebrating him about the book tonight. And all of that forms part of our conversation. Before then, though, there's a fantastic story about Free SHS, which we will tell. And we will tell it with a key protagonist who's also in the studio. He's a young man who is a student at the Presbyterian Boys Secondary School, Presec Legon. He's also the head boy at Presec. He's the school prefect of the school. He has a fascinating story about Free SHS. His name is Nana Kwejo Apaojesi. And what is the story? The story is that in 2012, when he was 10 years old, he made an inquiry about Free SHS because he was hoping that it will be realized and it will be a reality. That inquiry was made in 2012 and it went on the record. In 2017, when Free SHS started, he became a beneficiary. And yesterday in Koforidua, he met the president and reignited their earlier 2012 conversation. He's in the studio to talk to us about that. And he's also the school prefect right now of Presec Legon, the school that we all are very eternally proud of. So we will talk about that. Let's get back now to our introductory part of the program. And whilst we were combing Facebook, as we always do, was for the purpose of discussing day one of the capital banking course, we found this letter. It's a letter that is written by a Ghanaian to President Akufo-Addo, relating directly to the matters that are being prosecuted in courts and how the prosecution should be done. we have not made any opinions about this letter, and so we will share with you right now and read the letter through on your screen, and then you can make a decision on your own whether you agree with the writer or whether you disagree with the writer. I'm sure that government people who are watching or who will be told about this will also probably respond to this letter by one activist on Facebook. So here is the letter. I will roll up right now, and then we can all read. It says, it's a post by Onyameba, as he calls himself, and it is a letter to the president. It says, Mr. President, the retrieval of the process of corruption from former government officials is a major revenue source for government, and every amount of money returned willingly or retrieved by legal force from any former NDC official must be publicly made known to Ghanaians. Otherwise, the logical conclusion would be that the NPP is cutting deals with the NDC to cover up their corruption, in order that the NDC would also return the favor to cover up for the NPP's corruption when your party finds itself back in opposition. And he uses when. He doesn't say if. He says when your party finds itself back to opposition, suggesting that it's a fait accompli, it will happen. He doesn't quite say whether it will happen in the next election, which is few months away in 2020, but he just says it will happen. Okay, let's go on. But, he says, in capital, B-U-T in capital, mind you, Mr. President, there is no guarantee that it will be the NDC in power when Ghanaians dismiss your government. So, he says, do the NDC no favors. He's telling the president, do the NDC no favors, because eventually, as he says, if your government is no longer there, there's no guarantee that it will be the NDC. I don't know of any other political party or any other movement that has been put in place yet, but there's a warning here from this Facebooker, and it was quite a popular letter on Facebook, and that's how it caught our attention. It says, 1, please account for all stolen monies you have retrieved from the NDC since January 2017. Have there been stolen monies unaccounted for? Well, we'll put the question to the government people. Number 2, he says, please expose the NDC. I don't know what that means. I mean, the people, MPP people, have been talking about things that NDC have done. Kennedy Japan has been talking about it. Abronia has been talking about it. High-profile government officials have been talking about it. So when he says in his conclusive paragraphs 2 that please expose the NDC, I'm not so sure what Onyameba is talking about. Number 3, he says, remember that you are instructed by our constitution to jail. Hold it, Onyameba, hold it. The process of jailing is a detailed legal process. There must be a prosecution, as we've seen today. The charges must stand, and sometimes the charges may not stand. Lawyer Opon will tell us a lot about that when he joins us. And so the Constitution doesn't say somebody should jail. In fact, the Constitution will never say somebody should jail. It just says that they should prosecute. But I agree, generally, that if there are people to be prosecuted, they should be prosecuted. So number 3 says, again, remember that you are instructed by our Constitution to jail all past and present government officials who have caused financial loss to the state. Okay, so it's referring to the law causing financial loss to the state. And he's suggesting to the president that you do have the power to get your attorney general to prosecute matters relating to causing financial loss to the state. And he says the president must do that. He signs the letter, thank you, in the interest of Ghana. Okay, excellent. So that's from one Onyameba Atakesen. He puts that letter together, warning us about the process. Okay, so tonight we're going to get into full detail of the Capital Bank matter. They were in court today with as many as 32 counts of charges. The learned Attorney General read the charges in the court. And after the court process, she gave an interview, and so also did Dominic Ayini. Let us watch those 2 interviews, and then we'll come back to the studio and continue the program. Lawyer Opon is coming on shortly. Here is what happened after court. The learned Attorney General and the learned former Deputy Attorney General will tell you something in particularly striking about Kate Papafio. Let's have Kate's photograph on the TV again whilst I say that. So 2 lawyers, never before happened. I mean, it was a novel situation that happened today in court. And Madam Kate Papafio managed to pull together 2 lawyers, one from the opposition and one from the government. That's Kate Papafio in your photograph. And she comes from a legendary family. I mean, the people who are medical students or who are doctors will remember her father, Professor Papafio, who was a legendary professor of medicine in Ghana, and that's where she comes from. She's done a lot of work with Leroy Cable, and she's one of the shining stars of the Association of Ghana Industries. She's alleged to have collected some 70 million or so from the whole Capital Bank issue, and that's why she's in court. But she did something that was spectacular this morning that I'm guessing not all media picked up, even though some did. So she has two lawyers. One of her lawyers is an MPP MP, the former Deputy Minister for Energy, Katie Hammond, who is one of her lawyers. Katie Hammond is a member of Parliament. And the other one is the former Deputy Attorney General, Dominic Ayini, who is also a member of Parliament from the NDC side. So for the first time in court, there's one NDC MP and one MPP MP, both of them representing the woman on your screen now. She must be a very powerful woman to be able to deliver that in court. Katie Hammond, a former Deputy Minister of Energy under Kufuor's administration, Member of Parliament for Adansi-Asokwa in the Ashanti region, a key stronghold of the MPP, and Dominic Ayini, Member of Parliament for Bolgatanga. I have to get Dominic Ayini's constituency right. I got it right before the end of the program. But he's from Bolgatanga or Navrongo. Dominic Ayini is also the former Deputy Attorney General under President Mahama. So we'll get our lawyer to analyze that. So let's see what happened in court today. Gloria Kufu will speak first, and then you hear Dominic Ayini after. We'll be right back. Enjoy this. Have a look. This is what happened in court after the court showdown. This is what happened.
The merits of the case. I will briefly say that the monies that were given to Capital Bank were given to Capital Bank, neither to Essel, neither to Fitzgerald Odonko, neither to Nettie, neither to the lady accused person, Kwoti Papafio. The money, as the lawyers for the defense themselves said, was given to Capital Bank. Basic principle in law is that a company is a separate personality from the individuals. So if money is given to a bank, and mind you, for a specific purpose, and then individuals, be it that they have any interest in the bank, they are still separate and apart from the bank. If they use it differently, in a manner which is not consistent with the purpose for which the bank advanced the money, certainly there must be a problem.
We'll look at the charge sheet properly. The predominant charge is that of stealing. It means that there is an assumption that the monies, the subject matter of the criminal charges belonged to some other person and were dishonestly appropriated by the accused persons, either together or as individuals. And the basic point that I was making in court on behalf of the defense team is the fact that we need to look at the source of the money critically, because basically this is founded on liquidity support that was provided by the Bank of Ghana. Sorry. And the liquidity support is described in the facts grounding the charges as if it still remained the property of the Bank of Ghana. But we all know that liquidity support granted to a bank is more or less a loan with interest that is to be paid for by the bank. And therefore, we took the view that once the money was transferred to the bank and the bank disbursed it in accordance with its own internal procedures, it was a legitimate banking transaction that the bank engaged in. And therefore, there is no reason why any person should be charged, with stealing. And the reason why I thought it was going to be groundbreaking from a jurisprudential point of view is the fact that all these transactions were done with the consent of the bank, that is Capital Bank. At least there have been board approval by the duly constituted board members of the bank. Therefore, if all the internal management processes were complied with, we do not see how a charge of stealing would lie. But of course, we are at it's early days yet, because the prosecution is yet to adduce evidence. Maybe in the course of adducing the evidence, we'll see why a charge of stealing can be sustained. But you cannot steal my property with my consent. The law is very, very clear. If you look at the Criminal and other Offences Act, right? I think it's section 120, okay, 121 B, it is very, very clear that you cannot steal somebody's property with their consent. Even from a common sense point of view, it is impossible for you to accuse me of stealing when you have given me the property yourself, willingly and voluntarily. Of course, if I said things to you that represented fraudulent misrepresentations, in that case, you can say that I have defrauded you. But where I have taken your property with your own consent, I cannot be accused of stealing. That was the point that I was trying to make.
Welcome back to the show, and that was Dominic Ayini. So hold back, we'll get onto the legal discussion in some great detail when Yaopon joins us. So we'll have a lawyer in the studio. We're not worried about flouting the regulations of court where you cannot make prejudicial comments about the outcome of the case. We will certainly not make prejudicial comments about the outcome of the case because we don't want to appear before Cheba for having been dragged in contempt. Cheba is one of the finest judges that you can imagine. He's been on this program before. He actually dresses very well. Your photograph now, though, is Nana Kwejo Apao JC, school prefect of Presbyterian Boys Secondary School. Yes, hello. I'm very envious of you because when I was in Presec, I wasn't school prefect, and you are school prefect. Congratulations.
Thank you, sir.
How old are you now?
Please, I'm 17 years old.
This your story is dramatic, isn't it? So, please speak up a little bit. I want you to speak up a little bit so that we can hear you. Okay. When your story is quite dramatic. So you are in year 3 now.
Yes, please.
Okay. So the story has it that in 2012 you appeared at a rally at age 10. You were underage to attend a rally anyway. It was dangerous for you to be at a rally at age 10. Were you in the company of an adult?
Yes, please. My dad was with me then.
Your dad took you to the rally?
Yes, please.
Where did this rally occur?
It happened at Jackson Methodist Park in Koforidia.
Oh, that's where you lived?
Yes, please.
Methodist Park in Koforidia?
Yes, please.
And so you went to the rally?
Yes, please.
NPP rally?
Yes, please.
Your dad is an NPP guy, right?
Yes, please. In fact, he's the municipal chief executive of New Jabin South.
Oh, currently?
Yes, please.
Okay, so did you wear NPP colors that day?
No, please.
Okay, but he must have.
Yes, please.
Okay, so how then did you get the opportunity to ask the flag bearer questions?
Okay, so first of all, before I answer your question, I would like to thank you for hosting me on your program. And secondly, I would like to commend you for the good job you are doing for the country.
Oh, am I?
Yes, you are, of course.
Thank you very much.
Yeah, you're welcome. And lastly, I would like to also appreciate my dad for mentoring me up to now. I'm grateful to him. And so, to your question, in 2012, during that time, the president was going around campaigning, and he had a promise, and his promise was to implement the free SHS policy, which then I thought was an ambitious policy by then. And so during the campaign, I had the opportunity to go there with my dad, and there Lord Comey, who is the president director of operations, led me to the platform and gave me the opportunity to ask the president the question whether when he's voted into power, he'll be able to implement the free SHS policy. And there the president stood up, came to the platform and answered me and assured me that when he's voted into power, he'll be able to implement the free SHS policy. Fast forward 2017.
So how did you ask the question? No, I'm interested in that dramatic event. Did you speak in English?
Yes, I spoke in English.
You had a microphone?
Yes, please.
Lord Comey gave you the microphone?
Yes, please.
And you said what, Mr. Candidate or Nana Akufo-Addo?
In quotes, I said, Honorable Nana Addo Akufo-Addo,
yeah. When
you are voted into power, will you be able to implement the free SHS policy?
And he said he would?
Yes, please.
You were in JSS then?
No. I was in class 5.
Oh, you're only in class 5?
Yes, please.
Okay. So then what happened? Fast forward.
Fast forward 2017, the president was sworn in, and a few months after he was sworn in, he implemented the free SHS policy. And now we can see that over 1.2 million students are benefiting from this free SHS policy. And indeed, I commend the president for such a visionary policy, because education is the bedrock of every country. And for a country to be prosperous, it has to invest into education. You can look at countries like China, Korea, Japan, America, England, Canada. These countries have become superpowers in our modern world because they invested into education. And so if the country is also taking such a directive in investing in education, in the next 10 years to 15 years, Ghana is going to be a powerful country and is going to also compete in the global world.
So in 2017, what form were you in?
In 2017, I was in Form 1.
You were starting?
In fact, I I experienced the program. I was part of the maiden batch who experienced the free SHS policy.
I see.
Yes, please.
Then you got admission to Presec and you experienced. So you have not
Yes,
paid
please.
school fees
No, please.
since. So you are the badges of SSS1 free,
Yes,
SS2 free, SS3 free.
Yes, please.
So you are eternally grateful to the Ghanaian taxpayer
Yes.
for making it possible through the president's vision
Yes.
to have this happen.
Yes, please.
So did you see Nana Akufo-Addo in Koforidua at the weekend?
Yes, please.
He was happy to see you.
Yes, please.
And you were happy to see him. Did you carry him shoulder high?
Yeah, in fact, I shook him.
You should have carried him shoulder high because it's ensured that you have had free SHS and a lot of your friends, you know. So which primary school which JSS did you go to before you went to Presec?
I attended Madonna Junior High School.
In Koforidua?
Yes, please.
I see. And from there you came to Presec?
Yes, please.
Okay. How did you get elected as head boy of Presec?
It's because of my passion for service. You see, if you are very familiar with the words in your Bible, Jesus says something that if you aspire to be a leader, then you must have the will to serve. And so I believe that people saw that kind of passion within me, that I have the will to serve, and so that's why they voted for me as their head boy.
And you are 17 years old?
Yes, please.
Viewers, you see why I say Ghana has an amazing future that we shouldn't destroy. Ghana has an amazingly bright future that we shouldn't destroy with politics and actually useless politics. Look at this guy, 17 years old. When I was 17, I couldn't have said the things he's saying. 17 years old. Comes on a television program, he's not panicking, he's not frightened. Adults get here sometimes, they are frightened, I'm sorry to say. And he's articulating, he's not reading, he's 17 years old. That's the future of the country that we have. Let us keep it together and let's do away with useless politics. The useless one, propagated by some politicians, the useless politics. This is the future of the country. This is what we should appreciate. Chief, you've done well. What's your last words?
My last words is that before I leave, I would like to commend the Honorable Minister of Education, Dr. Matthew Poku-Prempeh, for the good job he has done for introducing the double track system to support this policy.
Oh, he's working?
Yes, he's working very hard.
The double track is working?
Yes, please. Yes, please.
So in Presec now, who are in school and who are not in school?
We have currently the Form 1s, the green track, and we also have the Form 2's green track.
So where's the gold track?
The gold track, they are at home.
Okay.
And they will be coming in November, on the 12th of November.
What are the electives that you are studying?
I'm studying biology, chemistry, elective maths. Yeah.
Biology, chemistry, and elective maths.
And
I like the system where you guys now do both elective maths and biology. We didn't used to do that. In our time, you either do biology or you do elective maths. We didn't combine it. Combining it is excellent, so that you can go to engineering and you can also go to medicine.
Yes, please.
So where are you going?
Medicine.
Oh, you want to go to medicine?
Yes, please.
You want to be a doctor?
Yes, please.
But that's long, 7 years. It's quite long. You are prepared for it?
Yes, please.
Really?
Yes.
Okay. So at 17, you finish soon, you go through. So by 27, you should, 10 years from now, you should be a doctor.
Yes, please.
We're looking forward to that. Do you know the kind of specialization that you want to do?
Yeah, I want to be an emergency doctor.
What's that? What is that? Accident doctor?
Yeah, not necessarily, but then those people who are rushed into the hospital and you have a doctor who would have to work on them before you get someone who is specialized at that.
Why do you want to do that?
There's a lot of money in that.
Oh, there's money in that. You found
Yes.
out. Okay, I like the way you're thinking about money. That's a great future. That's an amazing, great future for our country. Thank you very much.
And
Yeah,
also,
one more thing.
And also, I would like to tell the President and the Honorable Minister of Education that I am willing to offer myself as an ambassador to the free SHS policy. And I hope the President is listening to me now. The Honorable Minister
He's busy, but maybe one chief of staff, deputy chief of staff is listening, but the President is busy. He doesn't watch television like that.
The Honorable Minister of Education is also watching me.
Him, I'll send this video to. Dr. Matthew Poku-Prempeh, I'll send the video to him, so he will definitely see it.
I hope he's watching me, and I hope they grant me the opportunity to be an ambassador to this free SHS policy. So I move from schools to schools, I move to communities to talk to the indigenous of that community, to convince them that no, this is the kind of president we should all support to be able to push the agenda through. And before I leave, I would like to thank my headmaster, Mr. David Ojija, who has been a fatherly figure, the senior housemaster Kofi Yesu, my patrons, Sir Chris, Mr. Ablo, and the entire Presec community. I'm grateful to you guys. And also to my mom. Hi, mom. I know you are watching me. And to all the entire Presec community, I'm grateful.
Excellent, excellent, excellent. Great. Okay, super. You didn't do the appeal for fun for the conversation you had with me. It is a wonderful opportunity to launch the appeal for fun for the conversation.
Oh, yeah. And also to all other years, you know, this year we are organizing the Student Representative Council celebration. And I appeal to all other years, and not only other years, people who are willing to come and support.
Especially those who are envious of the other dear thing.
Yes, people are willing to come and support the SRC of Presec to be able to embark on its celebrations coming November.
Okay, so they should reach the school?
Yes, please.
Or they should reach you?
They can reach me or the school.
I'll put your number on our Facebook page so that they can reach you. Thank you so very much, Nana Kojo. And I have to say that his father brought him here into the studio. His father is with us. He's been a very supportive father. Also thank the headmaster for Presec who granted the permission for him to speak to us tonight. This is such an amazing free SHS story. Thank you very much. It's a pleasure. Thanks. So we'll talk again. I'll visit you in the school again like I did before.
Thank you, sir.
We'll talk. Okay, so Elpo is joining us. Before then, there's a free SHS song that was sung in Koforidia dedicated to the president. Watch it and we come back straight into the courtroom. Okay, welcome back to the show. Thank you very much for your time. And What's the time now? Sorry, it's 20 minutes to the top of the hour, 10 o'clock. This is Good Evening Ghana, and it's live. Lawyer Alpon is here in his sartorial elegance, Justice of the Appeal, Barrister at Law, and Solicitor of the Supreme Court of Ghana. Yeah, this is interesting. I mean, as I was saying, if every lawyer at 20 years at the bar would put up a book like that, it will be amazing. Did you put the book together to coincide with your 20th year at the bar?
Well, not really. But before then, let me say that I'm not yet Justice of the Court of Appeal. But anyway, I receive it.
Yes, Justice of the Appeal.
I hope one day
I'm talking about the English courts, actually.
One day I will qualify to be even higher. Yeah. Well, we started about 3 years ago. I had even forgotten that this year will be our 20th anniversary as lawyers. And I remember about 5 months ago on our platform, and then there was a suggestion that some of us should try and put some words together. Remember the first day at school at Legon, our mother, I call her so, Mrs. Mensah-Bonsu, asked us to put words together to formulate a title. And most of us couldn't do it. Not that we couldn't formulate title for books or so, but we were looking at the standard. And one of us who was the most maybe elderly, we call her Auntie Maggie, put the title Mileage in Pursuit of Knowledge. And this
That's
is
interesting.
mileage.
First year law student.
Yes, mileage.
Mileage in pursuit of knowledge.
Knowledge.
That's philosophical.
And that prevailed over all the others that the other persons put up. And since then, we have all been able to memorize it. And so then it occurred to me that I had to speed up and perhaps donate this book to the class. And so when it was published, I sought their permission and put PDF copy on the platform. And also when we met last weekend to have a meal, I donated copies of the hard copy
to each of them,
to those who were present. Okay. Yes. So
I went into the archives and get the photographs ready, producer. I went into the archives to pull up the list of some of the prominent persons that have been around with you to celebrate 20 years of the call to the bar. And the list is interesting. In fact, given the events of today, the list is rather very, very interesting. So it's as follows. They put the photograph there. I'll tell you who are celebrating 20 years at the bar with the Alpon. Yeah, they'll put the photographs there soon as we wait for it. And they said, okay, so this is His Lordship Justice Che Bafo. He's a member of the people who are 20 years at the bar. Justice Che Bafo is a justice of the High Court, Commercial Division Court 7. It was before him today that the accused persons were put. I'm not finished with Justice Che Bafo. And then you take his photograph off. So that's Justice Che Bafo. He's been in this studio before. Usually presents himself in his sartorial elegance. A very, very elegant judge. Very, very elegant. Has received wide respect from members of the bar. And it is widely expected that very, very soon he will join the justices of the appeal at the Court of Appeal here in Ghana. Justice Che Bafo is a member of Adom-Otchere's class. Let's go to the rest of the photographs. And as I said, given today's events, it is particularly interesting of this group of persons who are 20 years at the bar. Let's see the next photograph. So that is Evelyn Kilson. Now, Evelyn Kilson is one of the finest prosecutors that the Attorney General's Department has ever put together. Evelyn is, in the Attorney General's Department, she is sort of the number 2 to the Director of Public Prosecutions. She's also celebrating 20 years at the bar. And she was in court today with the Attorney General prosecuting the Capital Bank Court Day 1. That's why I said that given today's events, the class of 20 years old at the bar are doing a lot of different things in different angles in the interest of Mother Ghana. Everyone doing their own duty. So the judge, 20 years at the bar, Evelyn Kilson, one of the prosecutors who was in court today, 20 years at the bar, a very, very hard-working lady at the Attorney General's Department. Those of you who have had an encounter with the Attorney General's Department as a journalist looking for information, you will testify to the fact that this lady is a particularly nice woman, very, very hard-working. Okay, let's see if there are any other members of the 20-year call. Yay! There we go. Former Secretary to the President, John Dramani Mahama. Currently, the Dean of the Faculty of Law at the University of Ghana.
It's actually a school of law. It's a
school of law, yeah, sorry. It's no longer a faculty. The Dean of the School of Law, stepping in the shoes of great deans like Eko Daniels, like Eke Akunye here, like Professor Niashi Kote, who is now on the Supreme Court. Raymond Atuguba, Dr. Raymond Atuguba is also...
He's not prof.
Professor, okay. Full Professor Raymond Atuguba is also 20 years at the bar. Is there any other one that we can talk about? So,
I'll give you this, Ayariga.
No, not this one, please. We'll come back to this one in a minute.
Ayariga, Tadio, sorry.
Yeah, you're saying Dr. Ayariga, Mahama Ayariga, the Member of Parliament for Boku.
Yes,
he's also in your group?
Yeah, Tadio, sorry.
Tadio, sorry?
Yes.
That looks like... Tadio, sorry had something to do with this morning's event as well.
Did he?
His brief was held by 2 other lawyers. So that makes today's event particularly interesting. So what did you guys do at the weekend for celebrating 20 years at the bar? Did you jam all the way, all night long?
Oh, no. I mean, interestingly, I in particular had not met or seen a couple of them for the past 20 years, and some others too in a flash at some programs. So it was a reunion. We just tried to reminiscing.
So all of you have become very rich lawyers? Should we assume that 20 years after 20 years you have to be rich?
Well, richness is relative. But, I think we are breaking even and able to put 3 meals on the table for ourselves and our families. I think we give God the glory.
I see. Okay, let's go back to court this morning. Let's hear what the Learned Attorney General said, and then what Dominic Ayini said, and then we come to you to give us some analysis, and then we'll talk about this big book that you have in front of us. So let's see it again. The Learned Attorney General and Dominic Ayini.
Whilst I'm very reluctant to discuss the merits of the case, I will briefly say that the monies that were given to Capital Bank were given to Capital Bank, neither to Essel, neither to Fitzgerald Odonko, neither to Nettie, neither to the lady accused person, Kwoti Papafio. The money, as the lawyers for the defense themselves said, was given to Capital Bank. Basic principle in law is that a company is a separate personality from the individuals. So if money is given to a bank, and mind you, for a specific purpose, and then individuals, be it that they have any interest in the bank, they are still separate and apart from the bank. If they use it differently in a manner which is not consistent with the purpose for which the bank advanced the money, certainly there must be a problem.
If you look at the charge sheet properly, the predominant charge is that of stealing. It means that there is an assumption that the monies, the subject matter of the criminal charges belonged to some other person and were dishonestly appropriated by the accused persons, either together or as individuals. And the basic point that I was making in court on behalf of the defense team is the fact that we need to look at the source of the money critically, because basically this is founded on liquidity support that was provided by the Bank of Ghana. And the liquidity support is described in the facts grounding the charges as if it still remained the property of the Bank of Ghana. But we all know that liquidity support granted to a bank is more or less a loan with interest that is to be paid for by the bank. And therefore, we took the view that once the money was transferred to the bank and the bank disbursed it in accordance with its own internal procedures, it was a legitimate banking transaction that the bank engaged in. And therefore, there is no reason why any person should be charged, with stealing. And the reason why I thought it was going to be groundbreaking from a jurisprudential point of view is the fact that all these transactions were done with the consent of the bank, that is Capital Bank. At least there have been board approval by the duly constituted board members of the bank. Therefore, if all the internal management processes were complied with, we do not see how a charge of stealing would lie. But of course, we are at it's early days yet, because the prosecution is yet to adduce evidence. Maybe in the course of adducing the evidence, we'll see why a charge of stealing can be sustained. But you cannot steal my property with my consent. The law is very, very clear. If you look at the Criminal and other Offences Act, right? I think it's Section 120, okay, 121 B. It is very, very clear that you cannot steal somebody's property with their consent. Even from a common sense point of view, it is impossible for you to accuse me of stealing when you have given me the property yourself, willingly and voluntarily. Of course, if I said things to you that represented fraudulent misrepresentations, in that case, you can say that I have defrauded you. But where I have taken your property with your own consent, I cannot be accused of stealing. That was the point that I was trying to.
I heard a lawyer on Joy FM who had a slightly different view to this matter, and his point was that stealing may lie if board of directors meet and deliberately share the money, which is liquidity support for themselves, that it will still be stealing from the bank, because the money does not belong to them, it belongs to the bank. And they distinguish between the bank as an entity, body corporate, but an inanimate entity, and have other people who act on behalf of the bank. So if in acting on behalf of the bank, they breach what they call their duty to the bank, it is still stealing. But that's a question for Chebafo, I guess, so maybe we won't get there yet. However, Lawyer Pong, law students are worried this evening that the Banking Act, Act 930, prescribes offenses for punishment for certain offenses, including all the offenses that are listed in the 32 counts. They are wondering that the bank's collapse has been taken away. Shareholders have lost their shares in the bank. They have lost some of their property. That's sufficient punishment for the things that they have done. Government has taken over those properties, and those properties now belong to government, including some of the 610, and that's why perhaps they are not prosecuting for all the 610. Why then should they suffer another punishment in prosecution? They say there's something called double jeopardy. Maybe it will be that. What do you have to say about that?
Well, this is very interesting, and I must repeat that what I've said elsewhere. That I will usually not be tempted to discuss or highlight or analyze a matter that is in court. But since my learned seniors have led the way, perhaps one part of me will be tempted to give in and also express my candid opinion to the extent that I will be within the remit of the law. Now, this is a very interesting question, but one thing that has to be highlighted is that Act 930 came into effect in 2016. Now, you realize that nearly all the charges in relation to this present matter and some other banking cases that we are familiar with have sought to say that directors of a bank did so contrary to Act 930. But when you check the facts, all the transactions predated Act 930.
Oh, that's interesting.
The law is
930 came into effect 2016.
2016
of the election year.
Yeah, 2016.
But you're saying that the charges that have been preferred are based on activity that happened before
Act 930 came into effect.
And Constitution abhors the retrospective application of law.
Yes, Article 107.
Oh.
You see, so that is the focus. So we have had opportunity to point it out elsewhere, that you have to show that the transactions you are seeking to impugn were transactions that were conducted under Act 930 when Act 930 came into effect. Otherwise, you go back to the previous Banking Act. And the Constitution is also clear. Nothing is a crime. Some even say that a liability or criminal liability, unless there is a law that has specifically created an offense in relation to that act or omission, and usually provided a punishment for it. Article 19, 11, and also 5 are also opposite. So we need to look at it in terms of this law and the transaction. So when most of the transactions, or nearly all the transactions, are said to have taken place in 2014 and 2015, Act 930 requirements don't come in at all. So if you are brought under that, there may be a legitimate opposition to that. Then again, talking about the basic thing which some have rationalized it to be, how can I steal for myself, and so on. I've had the opportunity.
But can the prosecution at any time amend these things and remove the Act 930 bit of it and then put it in related to the old Act, or just purely the Criminal Offences Act?
Well, I sometimes see charge sheets as something that is ambulatory. I mean, it's something that can always be amended or changed.
Okay.
It's in motion. So that can be done, in my view.
Up until the time when the prosecution closed their case.
But if it becomes too regular, it may lead some to cast a doubt on the credibility of the whole process. And I don't think that is good for any prosecutor. Okay. And I know, as you said, these prosecutors are one of the finest in our generation, and they would have thought through these things. I have always said that no prosecution which is informed by politics succeeds in court, because in court is the law. Of course, we are humans, and if what we say is absolute, we won't go before a judge to determine it. So it will be interesting. And for example, one of my best teachers, Dr. Yini, makes that same point, and which I've also expressed my thoughts on in this book. That I think we are taking this corporate personality thing too far.
What is corporate personality?
Yes, that when you form a company, especially a company that is limited, a limited
so like Metro
company,
TV.
Yes. Once it is formed, those who formed it, or the subsequent shareholders, generally we see the owners, but I mean, the owners are just owners of the shares.
Yes.
But it said that the company owns its own assets. The assets belong to the company. The company can sue and be sued. The company can acquire its own assets and can also owe and be owed.
Yeah.
And usually we will cite the famous case of Solomon and Solomon, familiar to law students and maybe even those who have done commercial law and so on. Even in the UK, they have begun a process of fashioning out exceptions.
What's the point you're making?
There's a recent case, Press versus Petrodale. They said that there are exceptions to that principle, and that it is possible for a company to be seen as a trustee of the assets of other persons, including even shareholders. So for example,
what's the principle in Solomon and Solomon?
That's why I'm saying that once a company is formed, it's separate and independent
from the
shareholders. In terms of ownership of property and assets from the shareholders. Its property are its property.
Okay, so we form Metro TV and we buy a camera. That camera belongs to Metro TV.
So let's say the shareholders contribute and buy a camera.
Yes, so shareholders bring up $100,000 and we buy 10 cameras.
Yes, we are told that the shareholders are not the owners.
Yes, the company is the owner.
It becomes the company becomes the owner.
Yes.
But that is why I'm saying that the trend now is to formulate exceptions.
Okay.
To that rule. And those exceptions are clearly being developed. And so let me point this one to you in the Press and Petrodale Resources Limited case. It's 2013 UK case. And sometimes whilst we still stick to some of the tenets of the old, the very people who developed it are gradually in view of contemporary trends, as if I'm citing the title of my own book, are even moving away, or because current circumstances, which obviously may be different from 18 something when Solomon and Solomon was determined, would then call for exceptions to be fashioned. And so when you look at the Press and Petrodale, it said, subject to very limited exceptions, most of which are statutory, a company is a legal entity distinct from its shareholders. So you see, Now they are coming out with exceptions.
Subject to exceptions.
Yes. But we
So
take
the
Solomon and Solomon.
exceptions make the person and the company the same?
It doesn't, but there are circumstances where it goes on to say, in fact, it actually cited Solomon and Solomon. It goes on to say that there are instances where a company can be seen as a trustee of even the shareholders. Remember special purpose vehicles?
Yes.
In recent time, you hear SPV. They are nothing, limited liability companies, but they are nothing more than trustees.
Yeah.
Who are holding on property.
How does that
for
connect
to
this whole bank case that you're telling us?
I was going to Act 930. It states clearly that shareholders, if you now want to form a bank, you need about 400 million Ghana cedis.
Yes.
But you cannot borrow
that money.
It cannot be a loan.
It should be your own resources.
Your own resources, however you find it. So you go and sell your inheritance. Your father worked hard, left some property for you. Go and sell it. You go and seek assistance from your wife and your wife's father's grandfather and so on. You pull these resources together and form a bank. And yet when we are considering those who have interest in this bank, we don't count you the shareholder. It is very painful.
Who do we count?
Well, we usually
depositors.
We are usually told that depositors' money. But 400 million, which is invested in a company, if an outsider invests 2 million, that one we will count it. But what about the shareholder? That is where.
Okay, I get the point you're making. So I form Bank X.
Yes.
And I need 400 million to form it.
Yes.
So I form it, the bank is running.
Yes.
And somebody puts in 1 million. You are saying that the law makes the 1 million person more important than me, the 400.
It's not just the law, but I think it's those who are seeing the law in certain lenses think that shareholders don't matter.
But the fact that I put in 400 million doesn't mean if somebody brings 1 million, I take it.
It doesn't mean you should.
Yeah, I shouldn't misappropriate it.
See, we have, those of us who have worked in, especially banks, in a specialized area. Look, people deny themselves even dividends when due and even declared to be taken. Because most of these people have personal interest in it. Somebody
Very
calls
high
it
personal
my
interest.
baby.
Yeah.
You understand? So why will he kill his baby? For example, I'm not quoting anyway.
Well, okay.
So, and that is why I wonder how we will collapse over 300 or so microfinance companies and give it to one person as a shareholder, a director, to manage it. The person who formed his own bank couldn't, according to the authorities, manage it, but we give it to one person as a receiver to manage over 300 banks. And then the next time we hear that, oh, the bank is doing well. It's impossible. In my view, there must be something there. Because if you form a bank today, or like Metro TV, you are told that we have collapsed about 5 TV stations.
It's given to a receiver.
Go and take, Metro TV. Go and take all the assets as they've done to some of the banks. Why wouldn't Metro TV do better than any other TV station? Yeah. Because we've taken the assets of those other banks. Sometimes they are even far more. And especially...
And the bad assets you didn't take.
In the instance where a fresh bank is set up, we didn't have even a kiosk.
And they didn't have a single customer.
And you give a bank which until recently you yourself have declared to be one of the best in the country, and that among 3 banks, it is one of those banks that can even get the 400 million capitalization.
And
you
then
collapse that
after
bank,
3 months is gone.
And then within that same day, you collapse the bank that same day. You form a new bank, you form a company that same day. You form a bank, the bank is able, that company, in fact, at the time it was being formed at the Registrar General, it was even being called a bank, which is contrary to Act 930, that you can't call a company a bank unless a banking license has been given it. And yet, we called it a bank. Then, that same day, it applies for a license, purportedly, to operate as a bank. The license is given to it that same day. Another bank is collapsed, about 5 banks. We give all the access to that same bank. It starts operation on that day, and then the next day it is given certificate to commence business. Contrary to the Section 27 or so and 29 of the Companies Act, which even makes it an offense, criminal offense. that people are not prosecuted yet.
It looks like you are talking about very heavy matters. Very, very heavy matters. Let me bring you back to the events of today in court. So you are suggesting that the people at the Attorney General's put together of the whole process, as they have related to the Act 930, may be problematic?
Oh, well, I don't recollect any of the offense being linked to Act 930, but if they are, to the extent
but you're saying that they said that these things were done, they took a liquidity support, and they did all the things were done in 2014.
I thought they were highlighting the provisions in Act 29 to that extent, depending on the nature of the offense. Because you see, the offense of stealing, as Dr. Yini was asserting, is a term of art. I take it to be such, or a phrase which is very clear. I mean, you must deprive someone of his property without his consent.
That someone being the company. And that's a view that I heard on Joy FM by a lawyer, saying that someone is the company.
Yes, that's what I'm saying. That.
So if officers of the company, say directors, sat at a board meeting and shared the money among themselves, they have deprived that company of its resources.
If a company or officers of a company can make good decisions, they can also make bad decisions.
Yes.
But it doesn't make that bad decision an offense. Go to Act 930.
It doesn't make it a criminal
It doesn't make
offense.
it a criminal offense. A criminal offense.
I see. That's
now,
interesting.
Yes,
it's an offense. I mean, it's wrong.
Well, maybe morally, and that's not what I'm talking about. But it may not amount to a criminal offense. When you go to Act 930, it states clearly that the Bank of Ghana and its officers, the Attorney General, and any other person who is acting under the directive of Bank of Ghana are indemnified. In that they cannot be liable for any act of omission unless it can be shown that they engage in any act in bad faith.
Well, that's interesting.
Yes, it's in.
That's the standard of 930, Act 930 for officials who are
exactly.
applying it.
Exactly.
I
so
see.
when you apply this, and I think that, well, the famous adage, what is good for the goose is good for the gander, or for any other animal. It should be applied to also workers or directors or shareholders of a bank. In all cases, the question to ask, in my view, is, did they do it in good faith? In other words,
but how can you really can you do it in good faith if you have taken liquidity support of 610, and as the prosecution alleges, you have dissipated it?
Well,
how can that be in good faith?
I think I may be wrong to go deeper than where I have gotten to in relation to these charges. But the point is that it is very clear also, and I have had occasion to question this whole thing of charging people with crimes without establishing the criminal intent. You understand? What do you people call mens rea?
Mens rea.
The
criminal intent. That they had processed it. They had thought about it.
Thought about it. I'm going to commit an offense. Or engage in an act that will amount to intentional, let's say, deprivation of somebody's assets.
Or stealing.
Or stealing, dishonestly receiving and things like that. So you have to show, and that's why I'm saying, all this intenting aside, Act 930 has made it very clear. You have to establish that even the Attorney General, in acting under the directive of the Bank of Ghana or doing any act in relation to Act 930, had engaged in an act that can be said to be in bad faith. Otherwise, no liability will lie. And it is here. When you go to Section 151, Section 152, the various offenses have been given there, and then it goes on with the indemnity that has been provided against this. So why can't we apply the same? So in all cases, the strict liability principle I have argued here in this book, I find it to be unconstitutional. And strict liability principles don't require that you establish the intent, that he intentionally decided to commit an offense. So it makes the person guilty, and it is for him to prove his innocence, the opposite of what the Constitution requires. So Of course, I mean, it is said that even the devil cannot tell the intent of man. With all the powers that God gave the devil, he cannot predict or tell the intent of man. But when we put circumstantial evidence together, when you put direct evidence together, the objective test is applied. It can become clear in the absence of what I call voluntary admission that you have committed this offense. But they must always, I don't support strict liability offenses. So traffic light, the moment you cross the red light, you have committed an offense.
Yeah, strict liability.
Whether you thought that if you stop, the other car will hit you, or whether there's somebody in your car and you are rushing to take him to the hospital, once you cross the red light, generally, or once you're holding a bag and prohibited substance, let's say narcotics is found in you, it is your duty to now, and that is in the law, to now prove that you had authority to carry it. It's strict liability offense. And that is where we have to, in looking at this, one, the modern concept, the emerging trends on companies being seen as trustees of even the assets of shareholders should be looked at again critically. Solomon's principle is gradually being whittled down or being cleaned, being pruned down to fit modern circumstances. And I think that it is important that we look at it.
Very, very interesting. Let's now come to your book. And this is a beautiful book. If you can put the book back on the screen and let's talk about why did you call it Contemporary Trends in the Law of Immovable Property? What are we contemporary in, you know?
Well, I mean, my first title...
Can you please put the book up and let's have a look at it?
The first title was Emerging Trends or Modern Trends. And I thought that contemporary rather...
There it is on the screen. Contemporary Trends in the Law of Immovable Property in Ghana. Very, very interesting title. Yeah. And then you have the Hearts Bill. So this is how property started.
Yeah.
And then this is how property has now become the Trasaco Valley type of property.
Well, let's just say a bit about it. I mean, I try to challenge a few so-called established principles that you cannot tell a book by its cover. Totally wrong.
Yeah, you cannot tell. That's what they say.
But this book, once you look at just the cover...
you can tell exactly what it's saying.
Yes,
yeah,
it is not just about how property started, but it's about principles in relation to acquisition of land and immovable property.
Yeah.
So you will see that even down there where you see the modern building, there are Adinkra symbols. One of them is the Sankofa. You see it there.
Yeah.
And it is telling you that even whilst we are here and we think we are now in a modernized society, we should always remember the root of these modern principles.
Where we came from, yeah.
Yes. And if we forget, which is something that really motivated me, we have to go back to it and merge those principles as much as possible. We stated that customary law is flexible and it can accommodate changing circumstances. And that is why we put even this picture together. So apart from the evolution, showing the evolution of property, it's actually depicting the principles that we have really forgotten about and the need to merge them even in this modern time. So some usually call it land law, but I think that I was again motivated by the fact that the name that by law that subject is given is immovable property law, or the law of immovable property. And contemporary trends, because I've seen that contemporary can be a generational period, that over time we only see land law, how land was acquired by conquest, by first discovery, and by purchase, by gift. And then we move on to the family law. Family law, we already discussed family land, head of family accountability. And then we go to an aspect that relates to equity and succession. So we look at trusts, and then trust, usually we look at private trust. I give you this book in trust for my children and so on. I realized that we are leaving certain aspects there, so that when a person completes LLB, he should be able to understand what is called spousal right to property. When property is acquired in the course of the marriage, even by one person, at divorce, the story or
that's
the
if that unfortunate outcome occurs.
Yes, at divorce. I mean, it's almost, it occurs anyway.
So it's unfortunate.
So at that time, the principle had been that to be able to show that you have a share in it as a spouse, husband or wife, you must show what we call substantial contribution. Not
to the
just
property.
that. Some of the cases, oh my Lord, I went to the site, I bought kinky for the Masons, I fetched water for them.
Well, but I cleaned his clothes. I kept him well.
I washed for him. In fact,
Yes.
in those days, our mothers were doing it a lot.
Yes.
But today, of course, I mean, we don't discount what our
You are saying that wives of today don't wash, but they do something else.
I'm not saying that.
But they do something else.
I mean, the most difficult job is even taking care of the kids.
Yes, and
whilst
I think they still do that.
they are. But what the point I'm making is that in previous times, those were not counted. They call it spousal duties or wifely duties or a man's duties, maintenance. So if your wife has a house and all you did was to maintain the family, you cannot at that time say that you had interest in it because you use your money to buy food and your wife used her money to build the house. So over time, it changed. And now we've gotten to the stage where, until recently where another case came, the principle has been, this was, even though he had started, His Lordship Justice Adom-Otchere in the famous Mensa and Mensa No. 2 case, really concretized it and said that these so-called wifely duties and man's duties in marriage have to be counted, because perhaps without those wifely duties, you couldn't have gone out with peace of mind. They call it creation of congenial environment. Whilst you go away and you build, and only for you to say that, oh, well, the woman, show me your contribution in terms of cash. Then, of course, Article 22 has also been enacted. What is interesting about Article 22, which sometimes we forget, but fortunately, the Supreme Court, especially His Lordship Justice Yawapo, has explained it, and Justice Bafuboni in one case, that it's in two parts. The first part says that where property is acquired in the course of marriage and one of the spouses dies, let's say the man, if the man solely acquired it, quote and unquote, and he dies, whether or not the woman made any contribution at all is not the question. She's still entitled to a portion of the estate. And that may even mean property that was even acquired before marriage, because that is the estate of the person who died, the property he owned at the time of his death. The second part is during divorce. So the first is at the death of a spouse. The second one is divorce, dissolution of the marriage. With dissolution of the marriage, you still need to show that the property was jointly acquired, however it is determined, whether by way of wifely duties or the husband's duties or actual contribution in terms of monetary contribution. You have to establish that it was jointly acquired. But one interesting thing that is also coming up is what is marriage. So in one case, the Supreme Court held that to the extent that the woman was not able to show or establish that she was married to the spouse, the deceased spouse, what we call akotuejan. You live with a man for 10 years, he has not performed, quote and unquote, and I say quote and unquote for a reason, quote and unquote, perform the necessary rights to make you his wife, then in that case, Article 22 will not apply. And this is the case that is also here as well. And I have said that I have another perspective. it's always difficult for me to
So
say
in this book, do you show your perspectives?
Oh, yes, yes.
As opposed to decided cases?
Oh, yes, quite a lot. And I try not to say I disagree, of course, whether I disagree or not.
So you have analyzed decided cases in this book, and you have given potential other perspectives to it.
Yes. Without sounding boastful, I have.
Have you supported minority opinions in the case of a Court of Appeal decision or a Supreme Court decision?
Oh, yes. For example, this one that I'm talking about, this Adom-Otchere.
You have supported a minority opinion?
Yes. They, for example...
Kofi Komando used to do a lot of that. He writes articles to support the minority
Justice,
opinion.
when he was at the Court of Appeal. And reviewing another case that I think the former Chief Justice George Nawood gave, whether at the High Court or, yes, at the Court of Appeal, which rather said that it doesn't matter whether a man has performed the necessary right. Once they leave, that there are types of marriages, at least two main types. One, that you perform two main types of customary marriages, not as against statutory one and the Muhammad one, but customary marriages, at least there are two. One, that the people live, and in the eyes of the community, they behave as a husband and wife. They give examples like, you go to your hometown with him for a funeral of your mother, he makes a contribution, what we call nsawa, from where we come from. He pays the nsawa, or the funeral contribution. In the eyes of the people, you are seen as the husband. Just because you have not actually come with your family with a drink, you cannot say that you have not married. So I put the question, Adom-Otchere, is the bottle really empty? Adom-Otchere in Fanti means a bottle, an empty bottle, or a worthless bottle. So I asked the question, is the bottle really empty? When the man was following the woman to her hometown, and the woman was doing the same, and in the eyes of the people, hey, you knew our wife, our husband. And when there is a problem, usually that is where there is a problem. You say that, now Kramawarel, I mean, show me where I went to perform any customary right. And it's usually the men who are guilty of that, with all due respect. And it is very unfair. So I think that that principle which Justice Yaupel and the Court of Appeal express rather should prevail over that decision that the Supreme Court.
So when a student takes this book to read it, what's he going to get?
Oh, well, first of all, you have a book, and that's the forward by Justice Justice, who quoted one of the American presidents said. It's the most cherished property.
Yeah.
Because in the first place, even though it's called immovable property, it is about 8 subjects of law linked to immovable property. So you have the legal system aspect of immovable property, the evolution of customary law, the evolution of British colonialism and governance system, British legal system. Then we link into how all these influence the acquisition of property by conquest. And we've made the point that today you cannot acquire land by conquest because it is a criminal offense unless it is sanctioned by international law or your own law. Then you can maybe annex another country and so on. Then you move on to chapter 2, very, very important, constitutional law aspect. And on this, and in fact, the whole book started with that. It was an article that I started writing, and I decided to then add other things to it. To what extent has the Constitution influenced this existing interest in land? So those who are familiar know about the allodial title, and then they know about the freehold interest. Freehold, you have the customary law freehold, the common law freehold, and then we have the leasehold, we have the Obunu and the Busan, and those other quote-unquote minor interests. They are there. Then the Constitution, and I think it started mainly, substantially in 1969, under the 1969 Constitution, where they tried to say, in one sense, that a non-citizen of Ghana, sometimes they call alien also, but a non-citizen of Ghana cannot acquire a freehold interest in any land in Ghana. So at any one time, as they put it. So you'll be entitled to maybe a lease or so and so on. But when it comes to even stool land, it's even more serious. That is usually 50 years, maybe at any one time, as they put it. And so some people have interpreted that provision to also mean that then the creation of freeholds from a stool land, some say it's an abomination under the Constitution. But I have argued that it excludes subjects of the stool.
Okay.
So subjects of the stool
can
in
acquire
spite of
freehold.
that, yes, because the Constitution says subject to the provision of this Constitution.
So that if you are a Nungwa citizen,
yes,
you can acquire a freehold in Trasacco.
well, I would rather prefer Nungwa subject of the stool. Subject of
a
the
subject of
Nungwa
the
stool.
stool. If you are a subject of the
Citizenship may create
a subject of the Nungwa stool,
yes,
and the Trasacco land where automatically people take a lease of 55, 60, and 90 years, you as a subject can get a
well,
freehold.
if it's a Trasacco land, I take it to mean that somebody who owns Trasacco as a company has acquired a leasehold in it. Then it has ceased to be a stool land. The stool land is the vacant, unoccupied stool land.
So if you were the proprietor of the Trasacco company, going to take the land from the stool, but you were a Nungwa subject, you could take it as a freehold.
That's a very interesting question, and we have addressed it here. I hope
for commercial purposes.
Yes, I hope I may be permitted to say. There's a case that, Blue Skies.
Yes, the exporter of fruit juice.
Yes, they acquired land around in Sawem. I think they were doing pineapple, and so they got freehold. And then Lands Commission told them they wanted to register. In fact, they also gave portions to others.
Yeah.
And Lands Commission decided not to register the freehold, but rather the leasehold of 50 years. So the matter went to court. The argument is that the company was formed in Ghana. So strictly speaking, according to them, the assertion, it is quote unquote a Ghanaian
company.
It has a Ghanaian nationality.
Even though it's operated by a British gentleman.
Yes. And so, but the court ruled, Justice Cecil Mensah, one of the most brilliant judges in previous times, said that no, we need to look at the company in the eyes of who formed it. And to that extent, of course, the usual saying lifted the veil and said that since the company itself is not owned by a Ghanaian, if we don't check it that way, then non-citizens will form a company. All they want is to get a freehold interest in land, or even
and then hand it over,
or maybe more than 50 years lease. And then after that, the company is collapsed, and the property becomes the property of the shareholders. You understand? But then,
who may be non-subjects.
Yes, but even a stronger case to support that is the Balkan Energy case. You know, our good friend, Mr. Zankuma, he doesn't like how I've described him in my book when I gave him a copy. But I told him he's one of the best in terms of law. Argued that since the company was formed in Ghana, it has a Ghanaian nationality, and therefore it should. The transaction between that company and the government, remember the badge, was it Osajifo badge?
Osajifo badge, yeah.
Yes, Balkan Energy, was not an international commercial agreement to which Parliament, or in respect of it, Parliament must give ratification before it becomes a valid contract or agreement. Justice Dateba said clearly that yes, but this is one of the instances where the veil of incorporation will be lifted. Some prefer will be pierced. And then you see those behind it. And was able to give about 3 instances to show that though the company was established in Ghana, essentially it is not a Ghanaian company. But the point that I even make further is that even if the company is a Ghanaian company, is it a citizen? It is not a citizen of Ghana, because citizen of Ghana is clearly defined under the Constitution, Article 6.
How much are you going to sell this book as we conclude?
Oh, well, I mean, generally it's 500 Ghana cedis.
Oh, that's good. For how many pages?
I strategically and notionally left 3 pages before I got to 1,000.
1,000. Okay, so almost 1,000 page book.
So there are 3 empty sheets, and I left it just because I have in my mind that people will be critiquing it
and be writing something
on those 3 pages to make it 1,000.
Okay.
But otherwise, the first pages dealing with the authorities and so on themselves almost about 100 or so.
Ah, I see. So the text itself is about 800 pages.
No, it's 997.
Yeah.
997.
Oh, that's interesting. Congratulations. Real many congrats. We know that you spent a lot of time. We congratulate your family for supporting you to do this, your wife and children. You describe yourself as a regular tenant.
No, a visiting
tenant.
An involuntary visiting tenant.
As you were writing the book.
And it was also, and I have no shame, I also, dedicated to my 3 children, but ultimately to Dr. J.B. Damkwa. Also because apart from everything else, I relied heavily on his book on customary law, land and tenancies. But I owe it to our judges in particular, because most of it, they already made material from judgments that our judges have given. I've also acknowledged, in a very strange way, I've acknowledged a lot of people. I've acknowledged the support I got from the works of even our former president. And if you take it, I have described each of them as you have known them, the JMs and the gentle giants and all that, the free SGSS man and things like that, Abu Dhani, they are all there, because I say that without them, our bills that are passed by Parliament would have remained as bills. They wouldn't have been laws. And even the judicial service workers, with all due respect, the janitors, those who clean there, make it possible for us also to get our files together. The Council for Law Reporting, who puts these judgments together. Even, yes, members of Parliament, the lawmakers, the unseen drafters, as I call them, the Ghana Publishing House. All these people contribute to the building of our legal system, but sometimes, and above all also, or equally, I should say, our traditional rulers, because they are the ones that are formulated and also fashion, or continue to fashion the customary law that we have. Mind you, customary law is part of the laws of Ghana and Article 11. Yeah.
Excellent. So we will. So those who want some of the book, where do they go to?
Oh well, I mean, I have copies. You can get copies to at Legon
University Bookshop. Yeah.
Ghana Law School Bookshop.
Yeah.
The gentlemen and the ladies who sell around the courts.
They all have
quite a number.
And we will have some here too at Metro TV, so you can contact us for it.
We'll put some too on Amazon.
Amazing, excellent. That's easier for the technology-driven people.
Yes.
At 10:32.
There are quite a few too that will donate.
Okay.
And we'll also fix a date
for the big launch.
For the launch,
I will definitely be there.
I think it's a requirement.
So it is.
Sometime in November.
Thank you so very much, lawyer.
I'm grateful for the opportunity.
Thank you very much, lawyer. Upon 32 minutes past 10 o'clock. Thanks for watching. Good evening, and I'll be back with another edition on Thursday. Good night.